Okay, we're going to call the meeting to order. The Zoning Board of Appeals for August 3rd, 2023. Calling the meeting to order. Roll call. Let it be shown we have a quorum. We're missing three board members currently, but we'll proceed anyways. We have the minutes initially to approve for the July 6th meeting. Those who are in attendance, anybody have a chance to review those, see any edits?
I reviewed. I didn't see any edits, so I'm going to move to approve the minutes from the July 6th meeting.
Do we have a second?
Second.
Secretary seconds. All those in favor of approving the July minutes? All right, excellent, approved. Organizational and procedural items, I don't believe there are any. Unfinished business, we're pretty tidy, we don't have any. So before I go to new business, I'll read the chairman's preamble. The Zoning Board of Appeals is charged with the responsibility of granting variances to ordinance requirements after determining whether there exists an undue hardship upon an applicant. In determining whether or not to grant a variance, the board shall apply the criteria specified in the city code and ordinances to the facts of each case. The Zoning Board of Appeals does not create zoning, nor can it change zoning. Matters brought before the Zoning Board of Appeals are to be concerned only with variances from requirements of the zoning ordinance, the sign ordinance, and development and environmental ordinance. The board has no authority to grant variances for use, density, or height. Further, the board hears cases requesting an appeal to a staff interpretation or decision on those same ordinances. Final decisions of the Zoning Board of Appeals may be appealed by petitioning the Superior Court of DeKalb County within 30 days after the decision is rendered. First case is ZBA 23-11. Staff will walk us through that, please.
Okay, can you all hear me okay? All right, so the only case that we have on the agenda tonight is for a retaining wall to encroach into a side setback. So these are the existing conditions. In June 2022, a permit to build a pool and associated decking was issued to the property. During a routine inspection for the completed pool in December 2022, one of the city site inspectors noticed an unpermitted retaining wall on the property that's located within the side setback. What happened is that the pool was not built according to the approved site plan and was instead shifted closer to the western property edge by approximately 15 feet. As a result of this deviation from the original pool location, the retaining wall was built to make up for the grade change that occurred. These are the pool all the way to the photo all the way to the left, excuse me, shows the existing pool. And then the other two photos show the retaining wall as it currently exists today. So the applicant is proposing to finish the existing retaining wall by tapering its ends, which will increase the encroachment into the side setback slightly. The retaining wall will encroach a maximum of approximately 5 feet in the side setback and will be a maximum of 4 feet tall. It can be seen in red on the site plan here. The encroachment into the 4-foot retaining wall into the side setback would normally prompt a special administrative permit. However, since it's already been built, we're sending them through the variance process, as is our standard way. So the subject property has a slope of approximately 6 feet from the side setback line to the western property edge. The pool was built 15 feet closer to the western property edge than originally planned, extending almost entirely to the side setback line, which is an issue that was not created by the property owner. That was done by the contractor during construction. The city of Dunwoody mandates a 3-to-1 finished grade slope, and the resulting slope between the pool and the western property edge is too steep to level out without a retaining wall. The site plan on the left shows the approved location of the pool, and the site plan on the right shows the actual location of the pool. So you can see that it was shifted quite a bit. And so the retaining wall is sort of necessary to make up for that topography. Removal of the retaining wall would cause significant issues because the retaining wall was installed to help level out the side yard to accommodate the swimming pool and help stabilize the slope. Additionally, it was installed to address erosion issues that were affecting both the subject property and the adjacent property, 1468 Valley View Road. The property owner has coordinated with the adjacent neighbor at 1468 Valley View Road to obtain their approval of the project. Since the removal of the retaining wall could cause erosion issues, staff finds that the requested variance does not go beyond the minimum necessary to afford relief. And without accounting for the unique conditions of the site as it exists now, the strict application of the setbacks could cause a practical difficulty since there may be structural issues associated with removing the retaining wall at this phase since it holds up the swimming pool. Overall, staff finds that the project would not be detrimental to the public health, safety, or welfare, and that the request does meet the spirit and intent of the zoning ordinance. Based on these reasons, we are requesting approval subject to the following conditions, and there's only one. We're not including our normal condition of you have to do it within 2 years since the wall is basically done in this case. They just need to sort of taper it out on those sides. So we're just conditioning them to the site plan. I'm available for any questions.
Thank you. Board, any questions for staff? I have one. So the permit was for the pool, right? And it was the 15 feet is significant, right? Every month we approve variances in substantial compliance with the plan, right? So obviously that wasn't in substantial compliance with the plan. Thanks for clarifying it wasn't the homeowner's fault, because you had that in your brief as well. When I was like, it looks like it's their fault. But it's by association, I guess it's the contractor's fault. In that case, I mean, we wouldn't need the wall if that was the case, if they had adhered to that plan. So I don't know what the recourse is, or just curious how that happens when, who follows through on these, for instance, when we say substantial compliance?
Yeah, great question. So we've had some issues with pool contractors generally. And so our city engineer has now mandated pre-construction meetings where the contractor is required to stake out the location of the pool to make sure that they're sticking to the approved site plan. Because when we run into unpermitted retaining walls, it typically happens with pools, that they don't adhere exactly to the plan, and then they realize they need retaining walls, and then we run into all kinds of issues. So the pre-construction meetings are sort of designed to try to mitigate these problems before they happen, rather than having to go in on the back end. But that's a change that we made in, I think, the last 6 months or so. So this property is sort of one of the last ones to have issues, but we're hoping to just avoid these types of things in the future by really making contractors sort of prove that they're going to stick to their approved site plan. And this particular pool contractor, we've had multiple issues with. So if they ever submit another pool permit, we will be monitoring them very closely. We've had other problems with them.
Okay, thank you for clarifying that. Would the applicant care to address the board and state their case? Just state your name and address, please, when you get to the dais.
My wife tells me I talk too loud, so if I need to back up from the microphone, I can. Jeff Newland, 1476 Valley View, just right down the road there. Essentially, my wife contracted with a pool company, Bella Reed. She was led to believe that contracting with them would be more efficient. They controlled everything in-house, everything. It's one of the worst decisions we probably made in our life. So I'm actually threatening a lawsuit against them right now for several different reasons. They moved the pool unbeknownst to us, some convenience for them. By the time we found out what was going on, steep slope, they're like, now we need to do a retaining wall, for which they tried to increase the scope cost as well by charging us for said retaining wall. We were just, we were blown away, just not even incompetency, but indifference. And so now to this point, the retaining wall in my mind is kind of necessary. Otherwise, it's going to slide off into our neighbor's yard. Unfortunately, we're left picking up the pieces from the pool company. Since found out that they've got all kind of lawsuits against them in other states, fraud, just a bad actor as far as companies go. Don't really seem to care, take the money and do what they want, regardless of anything else, right? Regardless of what they told us, what they told the city. And so it's just a bad situation, unfortunately, that my wife and I have been left in, trying to fix what they, for lack of a better term, screwed up. So
okay.
The retaining wall is just, we're trying to dog ear a little bit, because the way they put it, our yard's just going to run off. And so the dog ear is kind of just to catch any kind of erosion and everything else, which I submitted some photos. It runs off into his driveway and creates a whole mess for him. And he's had other issues with a neighbor behind him who built a house and a pool and actually flooded his basement. So having a good relationship with him is key to me. And so I want to make sure I'm taking care of, our neighbor as we're supposed to as well.
Thank you. Doesn't appear to be any others here to speak in favor unless you want to. It's not necessary, but it's do you have a card? Good. Okay, please. Oh, excellent. Sure.
I'm in support of it. It's there's actually a similar.
Yes.
Joe McConnell, 1468 Valley View Road. So the picture you saw of the pool with the 3-car garage in the back set, that's my house. So but I'm in support of it. It's yeah, I've seen this variance a few other times and within Dunwoody. There's actually arguably one on the other side of Jeff's house. And I'm familiar with the drainage issues because we're on Valley View Road. If you know the road pretty well, there's a valley that runs through it and
Yep.
it's water runs downhill. And we had a small ranch house behind us that gentleman moved in and built a $1 million+ house and a pool. And I inherited some wash issues that I worked through with him. So, Jeff's got a good plan. He's kind of showed me his drainage plan and I'm support of it. I think clearly the retaining wall is a must. It has to be there, or this like the whole thing's gonna wash. To me, it's aesthetically clean. It looks good, and it's again the house itself. Even just that side of the house, for whatever reason, even just the house itself, if you look at the side, is probably less than 10 feet from the property line or whatever. But I'm in support of it. I think it looks good. And I think once he just is able to finish and taper the 2 sides off, and he's planning on putting some landscape at the bottom, as it goes to the pretty drain. There's a pretty large drain that's right there. I have a large culvert that goes under my driveway that is the main feeder of the rainwater down the valley. And it's a perfect place as he just puts in some landscape there. I think it'll be perfect, but I'm supportive of his plan. So, and I thank you guys for your time and your volunteer work. So,
Okay. Well, thank you. Yeah. All right. There are no one here in attendance, I don't think, can speak in opposition to this. So with that, we can close it for public comment and have board discussion. No discussion. Do I have any motions?
Yeah, I'll make a motion. Yep. I move to approve the request for variance from chapter 27, section 397 to allow a retaining wall to encroach into a side setback with the following conditions. Construction of the retaining wall must be in substantial compliance with the submitted site plan prepared by David L. Garrison and dated 6/8/2023. Please see Appendix A.
I second.
The first and second to approve the application. All those in favor? All right. All right. Unanimously approved. Thanks, guys. Yeah. Oh, you bet. Thank you. Any other business, board? No public comment. Well, yeah.
Is there a contractor do not use list that can be enforced to prevent this type of stuff from
Other than the
happening?
Dunwoody
So
Facebook page.
Yeah.
we can sort of track the information, and we do. It has to go through the solicitor and has to be sort of court approved. So it's a process, and we're doing sort of the very first steps, but it's not sort of a highly practical solution. What we do is we have sort of our informal list of people that we're having issues with consistently, and we're tracking those a bit more thoroughly. But
Are you able to advise residents when they apply for their, you cannot mention anything about,
No.
oh, you're using Bella Corp, whoever.
Yeah.
No, sometimes people ask us like, who's a good surveyor, who can we use, but we can't steer business in anyone's way. So we also can't, and we can't have a good list of people that we have good experiences with. We can't have a bad list until it's sort of so bad that we're sort of banning them from doing business in the city.
Yeah, because the applicant here, it looks like thankfully got off relatively easy in terms of how it could have gone a lot worse.
Yeah.
But I would imagine there's some cases that get pretty bad.
Yeah, and then if you would hear the representatives of the companies that are associated with this, they have like all sorts of reasons, you know, why what they did was the right thing to do, and it's, you know,
Two sides to every story.
Yeah,
Interesting.
yeah, that was significant. Thank you.
Thank you.
All right, no other comment, and we are adjourned.